Good morning.
Good morning.
Yes. The water before you is yours. We will start with a very quick round of introduction. My name is Martha Kome. I'm the chairperson of the Judicial Service Commission, and I welcome you for this interview.
Thank you very much.
Vice Chair.
Good morning.
Morning.
My name is Isaac Ruto. I'm the Vice Chair.
Thank you, Vice.
Good morning.
Good
Zilani
morning.
Caroline, Commissioner, you're welcome.
Thank you.
Good morning. I'm Charity Kisotu, a Commissioner. Welcome.
Thank you.
Good morning.
Good morning.
Omwanza Mbati, karibu.
Thank you.
Good morning.
Good morning, Judge.
I am Joki Dongo.
Thank you.
Yes, good morning, Council.
Good morning, Judge.
Anthony Mrima, Judge. Karibu sana.
Asante sana.
Good morning.
Good morning, Judge.
Fatuma Sichale, karibu sana.
Thank you.
Good morning.
Good morning.
Olwande Evelyn, you are welcome.
Thank you.
Good morning, Dorcas Odur, Senior Counsel and Attorney General.
Good morning, AG.
Good morning, Jacqueline Ngutia, Commissioner.
Okay, sorry.
Thank you. Good morning.
Yes.
Thank you.
Yes, thank you for that introduction. Mr. Emmanuel Omondi Bitta.
Thank you.
If you could start by telling us your county and your ethnicity.
CJ, I come from Siaya County, and I'm Luo. Luo.
Very well. We'll start the interview, which is more or less a conversation, because we want to get the best out of you and to see whether you fit the position you have applied for over Judge of the High Court. If you could start by painting a picture of who is an ideal judge of the High Court. And from that, you tell us how your experience, your qualifications, your knowledge, your expertise, the values you hold, make you suitable for that position. You have 5 minutes.
5 minutes. Thank you. My ideal judge. Can I name names? Or just
whatever is your
yes,
answer.
my ideal judge, I would say, of course, the ideal ones in service now, but I don't think it would be appropriate to use them. I would use an example of Justice Michael Hamoni, Justice Onyango Tieno, and Erastus Githinji. Because in my practice, they were neutral. They appeared neutral. When you appeared before them, you had a feeling that you had a chance. You had a chance. You will be able to convince them. They were polite. They wrote good decisions. They were balanced. They were fair. So my ideal judge would be in that mold. Somebody who knows the law. Somebody who makes litigants feel that they have a case. There is no bias. There is no predetermined. Somebody who's polite. Witnesses and counsels are free to express themselves. People who don't have integrity issues. In fact, it is very difficult to complain against them. So for me, that would be an ideal judge. Now, to myself, CJ, I'm a court lawyer through and through. I've been in court all my practice life. And I would say because of practice, I have developed the skill to work with the law, to produce outcomes. I think I'm a fair man, polite, I think I would recommend myself for the job if it was up to me. Let me say that. Let me just cover that so that I don't want to talk much. Then I'm asked questions, I'm not able to respond.
Very
So
well. I
that
think
would
the
be
other questions will keep coming from
Okay.
the other colleagues. Justice Mrima.
Thank you, Honorable CJ, and Council, welcome once again.
Thank you.
You can go ahead and check the water,
No, I was just opening it in case.
just in case.
Yes.
Okay. Now, Council, I must confess that you have been practicing before me for quite some time, and I have no doubt about your correct understanding of the law and especially the Constitution. But because we are in an interview, we have to go through this. Sitting in now as a judge, and you are dealing with an issue of limitation. You see, limitation of rights is very, very important because that is the do or die of this Constitution. The manner in which we limit these rights matters a lot. What are some of the factors which will come to your fingertips as a judge when you are dealing with the matter on limitation of rights?
Okay. I think the criteria is clearly set out in the text of the Constitution in terms of Article 24. The first one is you can only limit it by law.
Yes.
And my understanding is written law.
Yes.
And then there's an issue of proportionality in terms of that limitation. Because as a judge enforcing the Bill of Rights, you are supposed to give purpose to the intention of the Constitution. You're supposed to have a generous interpretation in terms of the right. You extend it to the greatest extent possible, which pushes a converse effect, it has a converse effect on the limitation, because the limitation must be justified in an open and democratic society. And it must be to an extent that it doesn't negate the right. I would say those are the factors that I would look at. And are there other measures that could be taken apart from the limitation? Those are the factors that will run through my mind when I'm considering that.
Thank you. Let's look at the requirement under the Act on registration of customary or traditional marriages.
Yes.
There is that requirement.
For 6 months.
And, yes. And I think your office is bestowed with that responsibility to ensure that all things are done. Now, how has been the uptake in respect of that since the inception of that law? And if the uptake has been low, what are the likely challenges? How can they be addressed? And in your view, is that registration of these customary marriages really necessary?
Those are many questions rolled up in one. Let me talk about the necessity. I think it is necessary.
Yes.
I think the assumption I have of legislation is the legislator is aware of the needs of society. So they make legislations to deal with issues in society. There is something that they were dealing with to require that registration. Maybe they realized that parties to such marriages are liable to be disenfranchised, or they are disadvantaged in certain places in terms of registration and benefits and all that. So in terms of the justification, I think over and above the presumption that the legislature knows what they're doing for society, I think to me it is justified. The issue of the uptick is an issue of sensitization, making the public aware of the requirement, because I don't think we've done enough to make the public aware that they need to register. I think if they are made aware, then I don't see a problem, because it's just an issue of registration. So that will explain the the law uptake. The consequences are, if the law requires you to register and you don't register, and then, for example, issues of succession arise, you will probably have some difficulties because now the issue of recognition of your marriage becomes an issue. And I think it can be dealt with by way of interpretation, so that because I think when a judge is interpreting the law, the judge does it in a context. It is not really in an abstract, particularly when you're dealing with issues that affect rights. So I think that will be my answer to the questions that you've posed.
Okay, and lastly,
yes,
there has also been attempts by the Office of the Honorable AG to regulate religious institutions and activities. I do not think whether we've met in headway. What do you think is the main challenge?
Regulating freedom of assembly and association has its inherent challenges, because you have difficulties coming up with a standard prescribing, practice of religious, people and stuff like that. I would prefer, if it was up to me, self-regulation. You just have broader, outlines of regulating religious, institutions and religious practices. Because the danger is, if you go too much, now you will be infringing on people's views and their conscience and their freedom to practice what they believe in.
Okay, thank you so much. I wish you the very best.
Thank you.
Yes. Mr. Bitta, let's go back to limitations of rights and Article 24 of the Constitution.
Yes.
You've clearly said that a right can only be limited by law.
Yes.
There must be proportionality, reasonableness, and everything.
Yes.
Currently, Kenya doesn't have a substantive contempt of court act prescribing penalties.
Yes.
If an appeal came before you challenging a fine or custodial sentence imposed for contempt of court, what is the constitutional and legal source of the court's power to impose that sentence? And how would you assess its validity in relation to Article 24?
I think that is an issue that has been problematic because ever since they declared the Contempt of Court Act unconstitutional, there is no statutory provision prescribing sentences and fines. And my reading of Article 24 tells me that a judge cannot, using common law, come up with a sentence or a fine, because sentencing policy is exclusively the mandate of the legislature. It is the legislature that prescribes sentences. Courts have a range of within where they can impose a sentence within a certain range, but it is the legislature that legislates sentences. It is a mandate.
Are you then saying that reliance on inherent jurisdiction or common law does not satisfy Article 24?
To me, it doesn't.
Why?
My reading of Article 24, it is written law. Written law. Because even if you go, a sentence is, there are principles that penalty must be known and prescribed before I offend. So when you're talking about common law, it is not known the range of sentences. There are rights there that I am entitled to the least severe one. If it is...
So what would be your recommendation?
My recommendation, there's need for legislation.
And without legislation?
Then you don't have power. I mean, this country is a country of the rule of law. You need law, written law. That is my view.
Secondly, you have been an assisting counsel or counsel assisting tribunals that have been
Yes.
investigating judges.
Yes.
In how many tribunals have you assisted?
AG, I've been in three tribunals. The first one for...
Without naming any names,
Yes.
would you just tell us what challenges you have faced and if there are any recommendations you'd like to make, because it is the JSC that is the mother of those tribunals. It's a byproduct of the JSC. What challenges have you met?
There are many challenges. There are many challenges that I see in that entire system. And there are challenges that will affect the judges themselves, and there are challenges that affect the tribunal investigating the judge. As regards the judges, it is, you know, the way that system works is a complaint is lodged before the JSC, and then the judge has to use his or her own mechanisms to go and represent themselves before the JSC. If they have not been in practice, it means they have to go and get a lawyer, to draft for them pleadings, to get for them witnesses. And the nature of the work of a judge is, many people will complain, not necessarily because there is a legal infraction, but there's that human aspect of a bad aftertaste of losing a case. So there is that cost element that system does not deal with. You have somebody...
Okay, that is one. Another?
That is one.
Uh-huh.
In terms of the tribunal is limited to the petition that has been forwarded to His Excellency the President. So that if they make an error in terms of either the grounds, that is transferred to the tribunal, and they are more or less confined to a very limited area of inquiry. So sometimes you can look at it and think, because you get furnished with copies of what happened before the JSC and all that, and you get a feeling that this one ought to have been translated into a ground, but it was not. Or the way this has been phrased is problematic in terms of proving it. So the system needs to find a way of dealing with that problem.
Okay, another
yes. one? I think for me those are the main ones. Those are the ones that I will pick from the top of my head. I'm in an interview.
So what would be your recommendation so that the next assisting counsel is not affected too much? What would you like, what would you recommend to not only the JSC, but you're recommending to the justice sector as a way of dealing with those challenges? Because if it's legislation, it has to be, it has to follow the process. If it is the issue of cost, somebody must bear it. So
yes.
What would you recommend?
I would recommend that, number one, JSC looks through its processes. Because the entire scheme depends on their product. It starts at the JSC. Let me give an example, just the last one that I did. There was a ground that was in the petition, and all we did was to call a witness who was not called. And we would wonder, this had no business coming here, because it was just a question of asking so and so. There are two lawyers in a case. One lawyer complains, the JSC doesn't call the other lawyer. So when we get the petition, we call the other lawyer, and he explains away everything, and you're like,
okay,
he didn't need to come here.
All right.
So I think there is need for a real look of
okay.
of the internal
finally,
process.
Yes. Finally, you have been in charge of the judicial review division.
Yes. I've done judicial review. I've been in charge of commercial and arbitration. Now I'm doing public law, which is broader than that.
How many cases are pending in courts with regard to judicial review or constitutional petitions?
Hey, there are many. There are many cases.
And why do you think there is a delay in resolution of those cases? And why do you think that we've got so many cases pending in terms of applications and not substantive hearings?
Let me start with just an example of constitutional petitions. Because sometimes I think the Kenyan public, people are not telling them the truth. Last year, from January to December, I think in Nairobi, there were slightly over 900 and something constitutional petitions. In that division, you have 3 judges. Just 3. These judges, if you look at their performance contract, they are supposed to conclude 10 cases in a year, 10 cases per month. And they work for, I would say 10 and a half months because they're entitled to leave. So if you translate that into figures, you probably get around 300 or 20 thereabouts. Them performing their contract with the Kenyan public. So you have a balance of 600 plus cases. Surely, if you start saying that it's a backlog, because backlog has a negative connotation, they have done what they're supposed to do. But these numbers are just beyond them. And it keeps adding. So it's a question of numbers. It's one of the solutions is what you're doing. Just get more people.
You started by saying that the Kenyan public is not well informed or educated. What do you mean?
You know, it's like people don't tell them that this is what we are facing and this is the ability we have, and therefore these are the expectations. Because I think we are putting a lot of expectations that are unrealistic.
Anyway, thank you.
Yes, that is just my observation.
Okay, thank you. Thank you.
Thank you, Honorable Chair. Mr. Bitta.
Yes, Judge.
I think it will just be one question from me.
Okay.
An advocate in private practice, he is acting for a seller of land, a vendor. There is a purchaser and a sum of Kenya shillings, 1 million shillings, has been paid by way of a deposit. The advocate misappropriates the money. He subsequently reported to the disciplinary committee of the Law Society and is found guilty of misappropriation of that sum of money. He is ordered to make a refund. Thereafter, he is arrested and charged with the offense of obtaining by false pretenses, contrary to Section 313 of the Penal Code. He now comes to your court.
Yes.
And he files a petition and says this trial is unfair, contrary to Article 50 of the Constitution. And he pleads, as it were, that there has been a tropos convict. How would you handle that petition?
He has not attached a copy of the decision of the criminal court.
No, it's not in dispute. True, he was taken to the LSK and he was disciplinary committee and they found him guilty.
But that's what a criminal court.
Excuse the use of the words guilty, but
yes.
Sometimes you find that the findings that come from the disciplinary committee actually speak of conviction and having found him guilty. But I'm using it loosely.
Okay.
Yes. Okay, he's been found culpable of having misappropriated the 1 million shillings.
I think that one clearly does not fall within Article 4 acquit because it's not a decision of a criminal court. He has not been charged with an offense before a competent court. He has not been found guilty by a competent court. That is not available to him.
All right. And then I now want to get to the area, and I think you're alluding to one reason Why would you find that he has not been found guilty? That was different. What would be informing your decision in coming to the conclusion that you are not found guilty? That was not a criminal charge.
Of course, you will not have a judgment and a decision of a court from point of evidence, and that Otofa acquits deals with you have been charged before a court that has the jurisdiction to determine criminal culpability.
So what does the disciplinary committee determine?
It's disciplinary. It is not a criminal court. It cannot hear and determine criminal cases. They don't have the jurisdiction.
So it deals with issues of professional misconduct.
It's disciplinary, yes.
All right. What about the standard of proof in either of the two issues or two matters before disciplinary committee and before a trial court?
My understanding is that before the trial court, of course, is beyond reasonable doubt. Disciplinary, I would suppose that it is it should be on a balance of probabilities. Yes.
So is it a civil case? Why is it on a balance of probability?
You know, I don't equate the disciplinary to a court of law.
I've just asked you.
Yes.
I appreciate that, Mr. Bitta.
Yes.
But we are talking about the standard of proof.
It's civil. It's a civil issue.
So what is the standard of proof? I've heard that you've been counsel
Yes.
in a tribunal now 3 times.
Yes.
What is the standard of proof in that tribunal?
It depends with the allegations. It depends with the allegations. For there are different grounds for the
Okay,
removal
the
of
allegation
yes.
here, just in the interest of time, and sorry to cut you short,
Yes.
the allegation is that of professional misconduct. Remember, we are now talking about the standard of proof in that tribunal,
Okay.
which I'm equating to the disciplinary committee. And I'm asking about the court is clear,
Yes.
beyond reasonable doubt. Now, before the disciplinary committee or the tribunal?
The tribunal's standard is, because it's sui generis, is satisfaction of the tribunal. That is the standard of tribunals for removal of judges. It is.
What do we call that in law? Because
it's an intermediary standard.
I was looking for that.
Yes.
Thank you. Thank you. Thank you, Honorable CJ.
Thank you, CJ. Counsel, I suppose you've read the case, the decision in Joseph Kaberia.
Joseph Kaberia.
Yes, the one that declared certain sections of the Penal Code as unconstitutional. I think section 2962, 297, and 204 of the Penal Code.
Oh, the one dealing with
robbery, attempted robbery.
Okay.
You've come across that.
I don't think so.
All right. But the point is
yes,
that the court declared certain sections of that Penal Code unconstitutional.
Okay.
And then suspended the declaration of invalidity for a certain time.
Okay. Is it the 3-judge matter in Kisumu?
Yes.
Okay.
Yes. Then subsequently, there was a subsequent petition
yes.
by Katiba that wanted, that say that there was no...
Yes, I'm aware of it.
You're aware of that?
Yes.
Okay. Now, when a court makes a declaration of unconstitutionality to a penal statute,
yes.
A statute that creates an offense, would it be appropriate to suspend its application?
When it comes to remedies or reliefs,
yes,
they are context specific. There is no general, sweeping The court looks at the issue, looks at the consequences of the issue in society, the problem as it is, and it fashions a relief based on the context.
Okay.
So I cannot say whether this is,
All right.
it depends on the context within which
Okay.
the court is determining.
So now the context is that there is an offense that has been created by statute.
Yes.
And some aggrieved Kenyan has gone to court and sought that and attacked that section, and then it's declared unconstitutional.
Yes.
And then there is a suspension of application or invalidity.
Yes.
What happens to those that have been convicted under that offense?
They would have to go back to court.
Yes.
Because you see, this is like something that has happened post-conviction.
Yes.
And they'll have to go back to court to seek some form of redress.
And what sort of redress will that be?
You know, my view is maybe you've been convicted with robbery and violence.
Yes.
But the facts can actually convict you of a lesser offense. So that is why some of these scenarios you must go individually. Then the judge will be able to sit and look at it, because you cannot occasion harm to society.
Okay.
Based on.
Okay, we'll go to that now. Now, then what happens in this period of suspension? You say, okay, go to Parliament and have that corrected.
Yes.
For instance, in this one, the direction from court was that go to Parliament, have this clarified so that there is no ambiguity.
Yes.
In this section. So in the intermediate, between the declaration and when Parliament makes that correction, what happens to the application of that section? Does it continue to apply?
Because it continues to apply.
Yes.
In the legal strict sense, it continues to apply. But these are the factors that the judge giving the order is supposed to consider in his mind before arriving at that order.
Okay.
Yes.
Now, then, if it continues to apply, what happens to an accused person's right under Article 25C, the right to a fair trial, and also Article 50, I think, N, the right not to be convicted on an offense that does not exist in law?
You see, it has been suspended, so it is in existence. That is one. Number two, that decision of the High Court can be upset in the Court of Appeal, because the High Court is not the final say on constitutional issues.
This one was never appealed.
Yes, so in this case, if I was the accused, I will raise that issue before the trial court.
So you go back to the trial court where the accused has already been, and now is a convict, to reopen so that he's released?
You must reopen it. You know, the presumption in terms of law is every public body, every government agency is presumed, the actions are presumed to be legal and lawful, unless...
Yes, the principle of legality.
Yes, so the principle of legality will apply.
Yes.
That you have been properly convicted. These supervening factors have happened, so you must go back to court to undo it.
So then the question that follows is then, what happens to a statute that has been declared unconstitutional? Does it mean that it ceases to exist from the time of declaration, or from the time of when the enactment was done?
When a statute is declared unconstitutional, in the proper legal sense,
yes,
it ceases to apply.
So it's as if it never existed. It was smitten on birth.
I wouldn't push it that way, because you see, there are also presumptions that what was done before it's being declared unconstitutional is proper and is sustained in law. So I wouldn't make those strong statements as regards that.
Okay.
You know, this is a case that is case specific. It's very difficult to have a sweeping view over such matters.
Okay. I mean, it's important because these are real issues that affect possibly thousands of Kenyans.
Yes.
Now, the last question I want to ask is about structural interdicts.
Yes.
You've heard about them?
Yes, I've heard about them.
Now, the difference in structural interdicts and the way they're implemented between, say, Kenya and where we borrowed in South Africa is that in South Africa, the parties report. They do periodical reports to court, and there's no representation. There's no oral representation. You give them, the court looks at it and then makes a sort of, takes the view of what happens. Now, in our case, we have what you call implementation hearings. So what is the extent that the court can go in an implementation hearing so that it does not reopen a case? How do you balance between supervision and not re-litigation?
You see, these are the issues that a judge is supposed to think before he gives a strategy, an interdict.
Yeah, but what is your experience? What's your experience if there is an implementation hearing?
Yes.
And then parties say no, this has not been done, this has not been done, and yet there was an order that had been given. Then government comes and says no, we are doing everything that we can do in good faith. Let me give you an example of Mitubel.
Yes.
In Mitubel there was an eviction which was it was not proper, and then there was an interdict that government will develop the property, and then the people who were evicted would have the first right to get the houses. Now government has started doing the houses, but it's not as quick as possible. So would that structural interdict take 10 years to supervise? Or, depending on the timeline of this?
The problems of supervision of structural interdicts arise from the way the interdict has been framed in the first place.
Yes.
This debate ought to have played in the judge's mind, because one of the factors before giving a structural interdict is the court able to supervise it? That is one of the key factors. If you give an interdict that is going to be problematic, then you've exercised your judicial judgment wrongly. It's a problem that you have occasioned.
Doesn't that also, wouldn't that mean that in certain instances structural interdicts will encroach into policy?
They do. They do.
So
it's just the extent.
So then how do you balance as a judge so that you're able to balance these competing interests?
The Constitution of Kenya 2010 has some very interesting provisions. Because if you read it, the traditional sense of a judge or a judicial officer, the Constitution gives the court an obligation to promote certain rights. Promoting is active. It's not a passive. So there are instances where the judge will look at the problem and see that for me really to give effect to these fundamental rights, there are certain steps that I will do that may encroach into policy. And he must do it because it's a constitutional duty reposed upon his office.
So coming now back to the last question on that. So should they be applicable only on socio-economic rights or in all areas? Because then if it's, for instance, from the criminal perspective, you've seen the problems it creates.
Yes.
Because you affect other rights under the Constitution that are also not non-derogable. But if it's a socio-economic right, you can do, but to what extent? Anyway, that is a matter for debate.
Yeah.
If you manage to...
Counsel, what I will say is this.
Yeah.
And that is the problem of what I call constitutional transplanting. You don't go to a jurisdiction, pick something, and try and transplant it in a context that doesn't suit it.
Okay.
Yes.
Thank you, Chief Justice.
Thank you.
Good afternoon once again. Still morning. Good morning, Council.
Good morning, good morning.
Do you want to take some water? Or
Sure.
Okay, please do. Sure. Water break moment.
Thank you.
Okay, thank you. Picking up from Commissioner Omwanza's question with
Yes.
regards to the provisions of the Penal Code that were declared unconstitutional in 2016, should then the police continue to investigate such offences and DPP continue to charge persons under those provisions of the Penal Code?
They shouldn't. They shouldn't, according to me.
Okay.
But that decision, I will say that under advice, that decision basically, the Constitution has given it to an independent office. That of the DPP and that of the IG. They're the ones who make that call. But from where I sit, I wouldn't advise that they do that.
So would you consider that as an overreach from where you sit?
An overreach by?
By the court.
No, it was not an overreach because the court has a duty to give effect to fundamental rights. Yes.
Okay.
Yes.
Thank you. I've gone through your sample writings. You submitted 2 submissions on constitutional petition, 1 submission on a JR, 2 appeals, 1 at the Court of Appeal and 1 at the East African Court of Justice. So your sample writings show exceptional analytical depth, strong command of precedent, and good grasp of institutional and structural constitutional questions. They demonstrate your ability to distill complex disputes, frame precise issues, and rigorously apply legal principle to factual jurisdictional context, including regional treaty law. Looking at them, you appear to be inclined toward purposive and contextual interpretative philosophy. I don't know whether that's true. Just reading at the 5. You know, it's 5. You've done so many.
Yes, I've done so many.
Yes.
I've done so many.
So am I right to conclude that way? The type of...
It comes with the work. I mean, I'm compelled to do it that way.
Okay.
Yes.
So some of them advance novel and well-grounded arguments, so I commend you for a good job. My first question, because that other one was just a general comment with regards to your sample writings. In constitutional petitions against the executive, most times petitioners invoke public interest to challenge the executive action or inaction. And when you look at the executive defense, they always put out the claim of national interest. And in recent past, we are hearing manifesto priorities to defend their actions.
Yes.
How should a judge distinguish the two?
Thank you. Thank you very much for that question. The PIL, the Constitution allows people to institute public interest litigation suits. And I think there is a misunderstanding. What the Constitution gives petitioners is a standing. Standing in terms of locus to challenge government action on the basis of unconstitutionality. That standing does not make them representatives of the people. So there is a misapprehension in the public that when I file a petition against the government, I have become a representative of the people. So you can't come to court and start saying, I don't agree with the legislature, whereas the legislature is the duly, elected representatives of the people. They have a mandate to speak on behalf of the people. In fact, the Constitution says they express the will of the people. So people have misunderstood that standing. It is just a standing that you're given. A standing to institute a claim. It doesn't put you at par with unelected representatives of the people. That is the first thing I would say.
Okay, proceed. Sorry.
Yes. Public interest, if you look at the scheme of the Constitution, has been institutionalized. The judiciary represents public interest, the executive represents public interest, the legislature represents public interest. Because Kenya is a democratic country. In fact, democracy is a doctrinal foundation of the Kenyan state. So you can't undermine the democratic processes and institutions just because you've been given a standing. So that needs to be appreciated. So when the government talks about national interest, It has been given to them through an exercise of sovereignty by the people. You may agree with them, you may not agree with them, but in a constitutional democracy, that must be respected. The issue of manifesto, because I heard the president talking about it. You see, a candidate goes to the electorate based on a political, agenda. Because I think people also don't appreciate that the Constitution is not like a lease, a legal document. It is a political document. And it must be construed as a political document. So when he goes to the people, meets a threshold, the people have spoken that we want you to implement the following. You may agree with him, you may not agree with him, but in a constitutional democracy, the court must protect that. So that you don't have a debate that I agree with this, I don't agree with this. What the court does is, in your implementation, are you doing it in accordance with the law? Are you working within the parameters of the law? But you cannot have a challenge on the wisdom or otherwise of a policy using public interest litigation. If you have that debate, you go to the legislature. That is the constitutionally designed forum for that debate.
So what is then the difference between public interest and national interest, other than the issue of saying you have locus to appear before the court?
National interest is public interest.
Mm.
Yes.
In fact, I was waiting for that.
Yes,
response.
it is public
Thank
interest.
You.
Thank you.
Thank you.
Yes, Mr. Bitta.
Thank you, Judge.
When I was trying to prepare questions to ask you, I found it a little challenging because you have practiced before the Supreme Court in many cases, before the Court of Appeal in many cases, in the High Court in many cases. In fact, I was wondering, perhaps you can answer this. There were vacancies in the Court of Appeal. There's a vacancy in the Supreme Court. Why have you chosen to go to you want to go to the High Court and not the other two courts? I'm curious, before I come to my next question.
No, it's a long story. I just wanted to be a lawyer when I began. And of course, I like what I'm doing. And I don't like naming names, but because you asked, the former Attorney General, Professor Gibu, sent me to the Supreme Court, to the Rules Committee of the Supreme Court. And I had been practicing in the Constitutional Division for a while. Then Justice Lenaola was elevated to the Supreme Court. So in the first meeting that he came there, he called me aside. He told me, Bitta, I think you need to join the High Court. There was a vacancy for land and environment court judges at the time. So I told him, Judge, there is this. He says, no. Don't go to the land. Don't go to employment. You go to the High Court. And so I've been thinking about it. Other judges and other friends have told me about it. So this time I thought I'm ready. Let me apply for the High Court. If I thought I had a chance in the Court of Appeal, I would have applied. But, you chance.
What do you mean if you had a chance? You have practiced before the courts.
Yes.
Court of Appeal included. What would make you think that you couldn't have? I'm just curious. Why the High Court and not the Court of Appeal or the Supreme Court?
I don't know. There are things that you just do. I don't have a...
Right. Because even as I'm trying to look through the jurisprudence of the Supreme Court, I was struggling to find a matter where you are not a party. It's a difficult thing.
Yes.
So let me just ask the one.
Yes.
This one I know you are not a party.
Okay.
Where we were determining the issue of mental incapacity when it comes to removal of a state officer. And we gave guidelines as to what a court would look at when they are determining whether a person has mental incapacity for the purpose of removal. What would the court? What were some of the guidelines?
Judge, I was in the MMG one.
Oh, you are also in it.
Yes.
Goodness. I think then let me just leave it at that. As you see, I'm not able to find, I really try to think of a case in terms of jurisprudence which you are not there. We've had lots of debates anyway on some of the issues which have been raised by my other colleagues here, so let me just leave it at that. Thank you.
Thank you, Judge.
Good afternoon once again. I'm not going to struggle as my sister Janjoki was struggling to find a question to ask you from jurisprudence coming from the Supreme Court.
Okay.
I just want to revisit the discussion you were earlier having with the Attorney General. You seem to be quite well versed with our performance framework, the targets and whatnot.
Yes, yes.
And you highlighted, or you're giving a hypothetical situation where you have 1,000 cases and you're required to complete 10 cases. And that comes to, if you take away the leave, 110 cases in a year. So this backlog is not going to end. And I agree with you, you can't blame it on the judge because resources are obviously limited. But now, as a person who's seeking to join the judiciary, and if you're successful to join the judiciary, what would your thinking be or your strategy be in addressing this issue of backlog? I'm sure you know the traditional methods that we've been using. You've seen the kind of progress we are making. From our last report, it was only 31% reduction. So what would you propose?
It's a difficult problem because one of the things I would say is almost counterintuitive. Mm-hmm. The more you make the system efficient, the more you make the system transparent, the more you make the system accountable, the more you attract disputes. So that now, people don't go for arbitration. People would rather go to the commercial division. Because I will see my lawyer online, I will see the documents online. If I'm aggrieved, I will appeal. So it's a very counterintuitive issue because the more you really try and make it efficient, the more you attract, you incentivize the public to bring disputes. Mm-hmm. So for me, that is why I was saying there is need for an honest conversation with the Kenyan public. Yesterday I was reading an article on BBC. A former judge of the court in the UK, I don't know whether it's true or false, and you were saying at, they call it Old Bailey, it's like the criminal division. They are now giving cases in 2030. 2030. Mm-hmm. Last month I was reading also an article dealing with the High Court in Allahabad. They had a backlog of 1 million cases. They tried, eventually they said this problem is a problem of personnel, let's just get more judges on board. Mm-hmm. Yes, so in trying to formulate a solution, I think the administration of the judiciary and JSC needs to be conscious of the fact that the more we improve this system, the more disputes will come to this system.
That realization has come upon us.
Yes.
The more efficient, in fact, the observation we've made even across the country, the more efficient a court is, the more cases are filed in that court. But are we to accept this as an endemic problem that we will never be able to solve? Or what are the innovative ways we can be able to deal, especially with the problem of backlog? It is our ideal situation, it is our dream around here, that we get to a point where we have cases being determined real time, or almost real time. So what are some of the suggestions, for example, as someone outside looking in and who is interacting a lot with us, that you'd give? I heard you mention something about recruiting more judges. We are doing that now.
Yes, yes.
But this is backlog. You can't keep just recruiting for backlog. And if we are to attain the ideal situation, what will we do with all these judges once we have sorted out the backlog problem? So what other ways do you think we can employ?
Sometimes I think it's management of disputes.
Mm-hmm.
Let me use the example of what we're talking about, public interest litigation.
Mm-hmm.
For me, I think that is one of the areas where the court has attracted a lot of unnecessary litigation. Because you will find, in one issue, you find 10 or 20 or 50 petitions filed by different people all over the country on the same issue.
Mm-hmm.
So you have numbers in your registry, but the dispute is the same.
Mm-hmm.
My view was some of those ones you will go the old-fashioned way of, if it's public interest, I make it known. You publish it, everybody joins in. Whoever wants, the others, we don't listen to it. And you make it a culture. It will reduce some of these cases.
So if I'm hearing you correct, you're suggesting policy intervention?
Yes.
Okay.
Yes.
Any other you can think of?
I can't, you know, it is a problem in all sectors of Kenya. The people in education are having the same problem. You know, we have a resource problem. And one of the things we realize that the Kenyan public is becoming more conscious of their rights, more conscious of the legal process. And you can't blame them and fault them for doing it. And because of the resource, challenges that we have, there are problems that we need to deal with now until the situation improves. But for me, those are the ones I would think of from the top of my head.
Okay.
Yes.
Thank you, and I wish you well.
Thank you,
my lady.
Thank you.
I've remembered a question.
Okay.
You've been obviously, you're well read, and therefore you've been following the Supreme Court of the United Kingdom. Last year, they made a very interesting decision regarding the issue of trans women accessing women's toilets. Are you aware of that decision?
Yes, I'm aware of
Can
that.
you just give us the scope of that decision and the reasoning behind the UK decision?
Their decision was simple. They said that being a man or a woman is a biological fact. It doesn't go beyond that because I think the other side was claiming that you can be psychologically a woman in a man's body. So the court says this extends only to, I don't know if they're interpreting a law, this only extends to biological, and they stopped at that.
So what's the implication of that decision? Why did they go that route? What was the implication in terms of the rights of women?
Yeah, because what the court decided was this constitutes a woman.
So now what I'm trying to get to. So the net effect is that men,
the trans,
cannot use
women. Yes.
And what is the effect of that? That trans men cannot use women's toilets? Is it does it protect women? Does it go to the safety of women?
Yes. It goes to the dignity. Because women need to be protected in that space.
What about women? What about in sports? Should trans women participate in women's sports?
Judge, you're asking policy decisions.
No, arising from now what the UK court has decided.
Yes.
That the issue of men and women is a biological fact.
Yes.
So in sports, should then...
In sports, I'm aware.
Yes.
There's a criteria. They check your...
But should biology
levels,
should that be also checked? The biology of it, because obviously, what you are saying is checked is biological.
I am aware in sports what they have done is because they say certain people have natural advantages.
So let me put it more clearly.
Yes.
So you're a high court judge.
Yes.
A matter comes before you that there is a trans woman who is now running for 1,500 meters, and will then be part of the Kenyan Olympic team. And the women who are biological athletes go and say, no, this trans woman should not be representing women you should not be in the women's field.
Okay.
What would you say and why?
What I would do, number one, is I would look at the law. Does the law make any provision dealing with this issue? Number two, I will ascertain the facts by getting experts to come and speak to that issue. There are people who have expertise in clarifying on that issue. And then I will make a decision based on the law, the facts, and the implications, the broader implications to society. Because this is a decision that will not be isolated to this incident. It will be setting a precedent. So I'll approach it with that kind of caution.
I still want to get back to
yes.
the rationale in the UK case.
Yes.
Because if you allow men into women's sports, can women be allowed into men's sports? The same way, and it will be, can women stay in men's prisons the way men want to stay in women's prisons? You know, so I'm still taking you back to the rationale of the UK decision, why it was made, and whether you would agree with the UK decision if you're a High Court judge.
I would agree with it because I'm inclined socially that way. And I would say this, that when you're making a decision, you must be conscious of the society, the context within which you're determining that decision. Because if you go ahead or outside society, the reaction to the law might not be.
Okay. Sorry, yes. I just want to pursue with one more question.
Yes.
I'm worried
yes.
that therefore you're worried about the culture.
Not the culture.
And not the rights. So do women have rights to have their own spaces for safety? Do they have rights to participate in their own sports?
100%, absolutely.
So it's not about society, it's about rights.
You know, you're asking me about the trans, not the women.
But the trans want to be women.
They cannot be because they are not.
Okay.
Can I follow up with a question? Just one question on that.
Yes.
So why would you need an expert to tell you whether a woman is a woman? Because you said you will ask for experts on this. Why would you need it's biological. If a woman is a woman, she's a woman. If it's a man, it's a man. Why would you need an expert?
You know, in competitive sports, there must be a standard of certain natural attributes, because you will find a natural woman with certain attributes that are above the standard, and therefore they will have a distinct advantage over their colleagues. So if that is the issue, you will need an expert to determine that.
But the UK Supreme Court said it's biological.
And I agree with them. I agree with them 100%.
Okay.
But we were arguing about the issue of trans, because trans is somebody who has moved from one to the other.
No.
Yes.
No.
Trans is.
No.
Yes.
Yeah.
I agree. So can we have Commissioner Kiso to take us to another area? We leave that one for open debate outside.
Yes, thank you.
Thank you, Honorable Chair, and allow me to take you away from that topic.
Okay.
Yeah, so you have practiced literally in all the courts, as Commissioner Judge Njoki had indicated.
That's correct.
So if you happen to be successful in High Court, would you just tell us the kind of maybe reforms that you would want to see in that court?
Reforms in the High Court?
Yeah.
Commissioner, my appreciation of government, because judiciary is part and parcel of government, is government operates on policies, procedures, and processes. So that when I go to the judiciary, you are entering a certain ecosystem that is regulated. Mm. You don't go in with, your superstar ideas. Mm-hmm. You work within the policies, the programs, and the processes in the judiciary. That is what will sustain that institution. Mm-hmm. Yes. So in terms of judicial reform, I will give my views to the administration to enrich the processes. Mm-hmm. But I wouldn't go in with my own, because there is a system, it's an ongoing system that is programmed and financed, and it has a checking mechanism and a reporting mechanism.
So have you been happy in whenever you go to practice in any of those courts?
I think they're doing a fantastic job.
Mm-hmm.
Of course, I cannot speak in respect to everybody, but generally, they're doing a fantastic job.
Okay.
From my own experience.
All right.
Yes.
Now, please also tell us how you reconcile between judicial oversight, independence, and accountability, and how does the judiciary account to the public?
One of the ways the judiciary accounts to the public is by giving reasoned decisions, because the product of the judiciary is decisions.
Mm.
The better, well-reasoned, clear, simple decisions you give to the public, the more you are accountable to the public, because they'll be able to appreciate this is based on this and this is based on this. So for me, that is one of the key accountability mechanisms in terms of the judicial function. And then speed within which disputes are resolved, and then integrity, because it goes to the confidence that people have in the system. That judicial sanity, is very important as an accountability, and transparency, which I was talking about, that if you have a problem in meeting a certain, just have a conversation and explain, and people will be reasonable enough to understand where you're coming from and the efforts that you're making to deliver to the public. For me, I think that would be my response to your question.
Okay.
Yes.
Thank you very much. I want to wish you all the best. The feedback that we have from the public is that you're a person of high integrity and good temperament, approachable and accommodative. Keep it up.
Thank you. Thank you.
All right.
Thank you, Honorable CJ. I have one or two questions for you.
Okay.
In your view, give us any three key attributes that one needs to possess to be able to succeed in this role as a judge of the High Court?
You need to be independent. Independent.
Uh-huh.
You need to have integrity. A person of integrity. And definitely you need to be hardworking if you're to discharge the functions of a judge.
Okay.
Those three are...
Speaking about integrity, do you have a situation where your integrity was put to test? What happened and how did you go about it?
You know, integrity, even this entire process, because I can come and tell you stuff and I know you have no way of verifying, so that I get the job. So integrity is tested on a daily basis in everything that you do in life.
Okay.
Yes.
So when you find yourself in such situations, how do you go about it?
You know, my view and my experience, and I learned very early, is that this profession feeds on reputation. If you take care of your reputation, you will be okay. If you don't, you will be in trouble. And it is in what you do on a daily basis, consistently.
Okay.
Yes.
What are the responsibilities of an employer in protecting employees from sexual harassment?
The responsibility is immense. You know, starting from even the text of the Constitution that apply between private citizens. You have an obligation to protect and to promote your fellow citizens' rights.
Uh-huh.
So you're supposed to come up with an environment that doesn't condone that. You're supposed to come up with policies that doesn't condone that. You must have a reporting and a punishing mechanism to make sure that does not take place in the workplace.
Okay.
Yes.
All right. Thank you, and I wish you well.
Thank you.
Yes, I have two questions. How do global human rights trends influence domestic legal and institutional frameworks?
Global human rights trends.
Yes.
They affect us because of, you know, that our constitution enjoins us to give effect to our international commitments and to general the general principles of international law. And you know, Kenya is not insular. We are in a global environment. We are in a global society that lives to protect and to promote human rights. So they do affect us.
So what role should developing countries play in shaping global governance norms rather than merely adapting them?
I think you're asking me whether they should be living what they preach. They should lead. They should lead by example. Yes.
I'm talking about during when it's being developed, isn't it?
Yes.
Yeah, for them to be able to shape.
It is by leading.
They practice it first, or
yes,
do they participate in?
Participate and practice.
Okay, thank you.
Yes, thank you, Vice Chair.
Yes. Okay, I think I should also have a parting shot.
Yes, EJ.
Following the general question, what do you think is the existential threat to the world peace and the rule of law?
I think it is the upsetting of the traditional mechanisms for dispute resolution. I think if you look at the current trends in the world, we are almost going back to the Hobbesian state of where, you know, might is right. That is my view. That.
Okay. Any example?
CJ, you know, I work for the government.
So you don't want to compromise. Okay, very
yes,
well.
Yes.
What do you understand by, emotional intelligence, and how you'd bring it to bear as a judge so that you conduct yourself properly?
Emotional intelligence is being aware of your surroundings, being conscious of your conduct and how it affects the people around you. And I think it speaks to the judges that I was talking about, that they are that aura of neutrality, that you're conscious that I really need to make these people feel like they will have a fair hearing.
Okay, but
yes,
you know, there are some people who come from their homes,
yes,
prepared to
yes,
scatter a judge.
I know that.
And confuse you.
I know that, I've seen it.
So how will you deal with those ones?
The law gives you certain powers to be able to administrate your courts. You can deal with it. And if it is necessary, I think even the law allows you to exclude them from the proceedings.
Okay,
yes,
very well. So I think this brings us to the end of a very interactive session with you, Mr. Bitta.
Yes, thank you.
But before we release you, we always give a candidate an opportunity also to engage us.
Okay.
The floor is yours.
First, CJ, I want to thank you. I thank you for the opportunity. It's a pleasure to appear before the Judicial Service Commission. And I know that maybe you've gotten used to being criticized, but I will I will congratulate you for having been able to negotiate the kind of financial support. Because I look at the number of judges that you've been able to onboard within this period of time, and I know how it is difficult to negotiate resources within government. So I will congratulate JSC for that. I know it's not easy. Other than that, I think that's all I will say. Thank you.
Okay. Thank you very much on behalf of the commissioners.
Yes.
We wish you well.
Okay.
We always wish the candidates well, even in your daily endeavors, what you're doing
Thank you.
for this country. We appreciate.
Thank you.
We will get in touch with you when we complete the exercise.
Asante sana.
You are now released. You can go with the writing pad
all
and
right.
even your water.
There will be a souvenir.
Yes, somebody will read you to where you can have some lunch, because we don't want to keep you very...
Asante sana.
Yes.
Thank you.